The courtroom on the fourth floor of the Hamilton County Courthouse smelled like old wood and floor cleaner that never quite gets the smell of old wood out. I had been in that room hundreds of times. I knew which chair scraped the floor during recess, which radiator ticked on cold mornings, and which bailiff would take a quiet word before proceedings, and which one absolutely wouldn't. I knew the room. But I had never sat on this particular side of the aisle before. I was at the respondent's table, the personal representative side, technically, since this was a civil probate matter rather than one of my criminal cases. Across the aisle, Dennis and Glenda sat shoulder to shoulder with their attorney, a man named Sutherland who had the practiced ease of a lawyer who has never truly feared a courtroom. Dennis was wearing a blazer that pulled across the shoulders. Glenda's hair had been freshly set, the silver neat. They were leaning toward each other, murmuring in the way of people who believe they are about to win something. They didn't look at me. Why would they? The last time they saw me, I was 6 years old, sitting on a plastic bench at a Greyhound bus terminal in Columbus, Ohio, wearing a t-shirt with a cartoon starfish on it, counting red suitcases. I let them have another 30 seconds. I opened my folder. I uncapped my pen. I felt the small weight of the blue enamel bird pinned to my lapel, the one Miriam Holt gave me on my first day of first grade. The one she said was because wrens always find their way home, no matter how far they wander. I had worn it to every trial that mattered to me for the past 8 years. Then I looked up, directly across the aisle, at Glenda. She was mid-sentence. She stopped. She didn't know why she stopped. I could see it, that pause that comes before recognition, the brain trying to place a face without a file. She looked at my blazer. She looked at my folder. She looked at the blue bird pin. Her mouth closed. "Miss Holt," the clerk was addressing me. "Are you prepared to proceed?" "I am," I said. I watched Glenda's hand find Dennis's sleeve. "I am Felicity Holt. I am 32 years old. I am an assistant district attorney for Hamilton County, Ohio. And before any of that, before the bar exam, before the law degree, before the scholarship and the honor roll and the years of reading case files until my eyes ached, I was a little girl who counted to 20 and was still alone when she finished. I need to go back before I take you into that courtroom, because the story doesn't start there. It starts in the summer of 1998, which was the summer I learned that love has conditions, and that sometimes the condition is that you've just become too expensive to keep. My biological parents, I'll call them Dennis and Glenda, because that is what they are to me now, names and nothing more, weren't cruel in the ways you'd recognize from after-school specials. There was no screaming, no bruises, no single dramatic scene I could frame and say, that was the moment. What there was instead was a kind of quiet arithmetic. Dennis was always running numbers in his head, the way some people work a rosary. Glenda watched him and matched his conclusions. By the summer I was 6, whatever equation they were running had put me on the wrong side of the ledger. We drove to Columbus on a Tuesday in July. I remembered the drive because my juice box leaked on my shorts, and Glenda spent 20 minutes annoyed with me about it. The Greyhound terminal off Marconi Boulevard was loud and smelled like diesel and bodies, and the particular fast food that has no business being eaten before 10 in the morning. I had never been inside a bus station. It felt enormous and strange and a little exciting, the way loud public spaces are exciting to children who don't yet understand that they can also be very lonely. My older brother Leland was 14 that summer. He stayed home. I didn't know why at the time. Later he would tell me he hadn't understood what was happening, that he thought they were just taking me on an errand, that he figured it out only when dinner time came and went, and nobody called, and, even at 14, he understood in his gut that nobody was going to. Dennis walked me to a row of plastic bucket seats near the terminal's main hall. The seats were the orange and brown of a place that hadn't been redecorated since the Ford administration. He sat me down. He pointed at the wide glass doors facing the street. "See all those people coming in with luggage," he said. "Yes," I said. "Count every red suitcase that comes through those doors," he said. "When you get to 20, we'll be back. We just have to go get the tickets." He glanced at Glenda. She was already looking at the exit sign above the far set of doors, not the entrance. The exit. I counted. I was a precise counter. I had learned my numbers early because Glenda's patience for repetition ran out fast. 3 red suitcases. I wasn't sure if the strap counted, so I didn't count it. 5. 6. A red duffel bag with a broken wheel. 7. The morning crowd thinned. The PA system called a departure to Pittsburgh. Then 1 to Louisville. 8. 9. Somewhere around 11, the doors began letting more people out than in, and then mostly the custodial staff was moving through, pushing brooms, looking at the floor. I sat very still. I had learned, in the accumulated knowledge of 6 years, that still children don't get yelled at. Still children don't cause inconvenience. Still children wait. The light through the terminal windows went from white to yellow. My starfish t-shirt was stiff where the juice had dried. I was still sitting on that bench when a woman in a yellow apron came through the side door of the lunch counter attached to the terminal's far wall and noticed me. Her name was Miriam Holt. She was 56 years old. She had run her lunch counter for 23 years, since her husband died, and she decided that the only way through grief was through useful work. She was not soft. She had a directness that some people read as coldness until they realized it was the most honest form of attention she knew how to give. She knelt in front of me without hesitation, without making a production of her knees. And she looked at me the way someone looks when they have already decided that a problem in front of them is their problem to solve. "Where are your parents, honey?" she asked. I pointed at the exit doors. "They went to get tickets," I said. "I'm counting red suitcases. When I get to 20, they'll be back." Miriam looked at the exit doors for a long moment. She looked at me. She looked at the bench, at how carefully I was sitting, at the way I wasn't crying, the particular stillness of a child who has learned that crying doesn't reliably produce results. She did not tell me they were coming back. That was the thing I understood only much later, looking at it through adult eyes. She didn't make that promise. She said, "Okay, but how about you count from inside the diner where it's cooler? I've got cold lemonade." She called the police from her office behind the counter. She sat with me through the report, through the wait, through the foster care intake that happened at the terminal while I ate a grilled cheese, and tried to understand what was being decided about me. She asked the caseworker right there in front of everyone whether she could be listed as a potential placement. The caseworker said that wasn't how it worked. Miriam said she understood and asked for the correct forms anyway. It took 8 months. She got me. Miriam Holt was not a comfortable person to be raised by, and I mean that as the highest compliment in my possession. She did not let me feel sorry for myself past a reasonable interval. She did not pretend that what Dennis and Glenda had done was anything other than what it was. When I was old enough to ask her directly, 9, I think, at the kitchen table after school, she put her hands flat on the oilcloth and said, "They left you. It was wrong. You did nothing to deserve it. Those are the facts." She delivered the facts the way she talked about weather. They happened. You dressed accordingly. She took me to her attorney when I was 12 and I was formally adopted. My last name became Holt. There was a cake from the bakery on 5th Street. Miriam did not like fanfare, but she bought the cake, which meant it mattered. What I did not know, what she never told me, and what I discovered only at the reading of her will, was that Miriam Holt had spent 3 decades quietly buying small properties across central Ohio. A duplex in Clintonville, a strip of commercial space in Westerville, a storage facility she'd picked up for nearly nothing in a county that looked depressed and turned out to be sitting at the edge of a development wave. She had reinvested every surplus dollar for 23 years before she met me, and for 17 years after. She lived above the diner. She drove a 2003 Honda Civic. She wore the same 12 cardigans in rotation and didn't apologize for any of them. She died of congestive heart failure on a Wednesday morning in October. In the hospital bed, her doctor had moved to her living room in the last weeks, with her hand in mine, and her favorite cardigan folded over the back of the chair because she'd asked me to put it there. The total value of the estate, $2.8 million all to me. The story ran in the Inquirer first. Local attorney Innert's surprise fortune. I had been working in the Hamilton County DA's office for 4 years by then, had moved to Cincinnati, had a mortgage and a case calendar and a life I had built entirely from the outside in. My name was in the paper next to a photo they must have pulled from the county website. It took 11 days for Dennis and Glenda to file suit. I want you to understand the moment I was served, because it mattered. I wasn't at my desk. I was in a Kroger parking lot on a Saturday morning in November, holding a bag with coffee and a rotisserie chicken, when a man in a gray anorak appeared at my elbow, with the specific unhurried approach of someone who has done this 1,000 times. He handed me the envelope with a kind of professional neutrality. I thanked him, he nodded and walked away. The filing challenged Miriam's will on grounds of undue influence and exploitation of a vulnerable elder, combined with an assertion of biological family rights to contest the estate. Plaintiffs, Dennis Marsh and Glenda Marsh of Columbus, Ohio. I stood in the parking lot. The chicken was warm through the bag. I read the document 3 times the way I read everything I planned to dismantle. Once for content, once for structure, once for the gaps. The gaps were significant. Dennis and Glenda had no standing to challenge the will of a woman who had legally adopted their child. Their parental rights had been terminated by the state of Ohio in 1999. The claim was essentially a claim on me, and that claim had been extinguished by a family court judge 25 years ago. Sutherland was competent, but whoever had briefed him had not given him the full picture. I called my personal attorney, a woman named Hargrove, meticulous and unbothered, and said, "Don't file to dismiss yet. I want to know what they've been doing since 1998. Go back to the beginning." What she found took 12 days and most of a case of coffee. The record was not hidden. It was just old. Paper files, imperfectly digitized, sitting in a Franklin County court archive under a case number closed for 25 years. Hargrove found it on a Tuesday and called me at 7 in the morning, which she never does. "Felicity," she said, "they sued Greyhound." I put down my coffee. "When?" 1999, settled out of court, $180,000. She read me the relevant section. The plaintiffs, Dennis and Glenda Marsh, asserted that on July 14, 1998, they had entrusted their minor daughter to a Greyhound terminal employee for supervised waiting while completing a ticketing transaction, and that through the company's negligent failure to monitor the child, she had become separated from her family. They claimed emotional distress, loss of familial consortium, and ongoing suffering from the disappearance of their beloved daughter. Settlement $180,000, paid in full March 1999. Attached was an affidavit. The undersigned parties acknowledged that the minor child, Felicity Ann Marsh, has been lost to the foster care system and is considered for purposes of this settlement to be permanently separated from the biological family. The undersigned released the carrier from all future claims related to this incident and acknowledged this settlement as full and final resolution. Dennis's signature, Glenda's signature. They had taken $180,000 from me. They had signed a legal document declaring I was gone, permanently, finally, for purposes of settlement, and they had taken the money and moved forward. They had liquidated me and spent the proceeds. And now 3 decades later, I had a value again, and they had come back to collect. Do we go to trial? Hargrove asked. We go to trial, I said. What Hargrove didn't know yet was that Leland had been calling me every few days since the suit was filed, circling something he couldn't quite bring himself to say directly. He finally called on a Thursday evening and said, I took something from their house when I helped them move in 2021. I didn't know why. I just took it. He drove down that weekend with a shoebox that smelled like attic insulation and old paper. Inside, a bundle of receipts from the Scioto Downs Casino in Columbus, dated July 15th through 19th, 1998. The 4 days immediately following the day they left me at the terminal, a motel receipt from the same dates. A printed bank deposit confirmation dated March 4th, 1999, for an amount that aligned with the Greyhound settlement check. And at the bottom, a birthday card, Dennis to Glenda. The handwriting was his. It said, Happy early birthday. Here's to a fresh start. Dated July 21st, 1998, 1 week after they drove away. Leland sat across from me at my kitchen table, with his hands wrapped around a mug of tea and a stillness about him that I recognized because I'd spent years cultivating the same thing. I used to think I was the lucky one, he said. The one who got to stay. I know. I wasn't, though. He looked at the table. They used her story for years. Donations from the church. The neighbors brought food for almost 2 years. There was a woman from their congregation who came by every month with casseroles, thinking she was helping a grieving family. They let her think that. They used the missing sister as, currency. Every time the money ran tight, every time Dad lost at the casino, they would bring her up again. He exhaled slowly. I was in the middle of it for 30 years, and I didn't figure it out until I was an adult. I thought that was what grief looked like. It wasn't, I said. No, he said. It wasn't. The civil hearing was on a Thursday. I arrived before anyone else, placed my folder on the respondent's table, and pinned the blue wren to my lapel. When Dennis and Glenda came in with Sutherland, they didn't recognize me. They sat across the aisle and conferred, and they looked the way they had always looked in my memory, like people who expected the outcome to be decided before the room was called to order. Then I looked at Glenda, and she stopped. Not recognition. Not yet. Just the animal instinct that something in the room had shifted, that a variable had been introduced that wasn't in the filing. The hearing opened. Sutherland made his argument: biological connection, estate accountability, questions of undue influence. It was professionally constructed. It was also built on a foundation that had been rotted out from underneath for 25 years without anyone telling him. When Sutherland finished, I stood. My name is Felicity Holt, I said. I looked at Dennis and Glenda when I said it. I am the sole beneficiary of the estate of Miriam Jean Holt, who legally adopted me in February of 1999 after the plaintiff's parental rights were terminated by the state of Ohio. I'd like to address a threshold question before we proceed. I placed the certified copy of the 1999 settlement agreement on the table in front of the judge. Your Honor, the plaintiffs have asserted biological family rights as their basis for standing. However, on March 1, 1999, Dennis and Glenda Marsh signed a sworn affidavit attached to a civil settlement with the Greyhound Bus Company, in which they acknowledged that their minor daughter was, and I'm quoting, permanently separated from the biological family. They received $180,000 in exchange for releasing all future claims relating to the child. Sutherland had gone very still. If the plaintiffs now claim their daughter is alive and present in this courtroom, I continued, one of two things is true. Either they committed fraud against Greyhound in 1999 by accepting a settlement for a child they knew was alive in the foster care system, which constitutes fraudulent misrepresentation, or they are misrepresenting their relationship to me to this court today. Either way, their standing is void. The parental rights were terminated. The child named in that settlement does not legally exist as their daughter. The woman standing at this table is the legally adopted daughter of Miriam Holt, and the estate of Miriam Holt is not subject to challenge by parties with no recognized claim. The room was quiet, the good kind of quiet, the kind I had learned to use. The judge looked at the settlement agreement. She looked at Dennis and Glenda. She looked at Sutherland, who was making very small movements with his jaw. "Mr. Sutherland," the judge said, "were you aware of this settlement prior to today?" A pause long enough to have its own weather. "No, Your Honor, I was not." I sat down. Glenda was gripping Dennis's arm. Dennis had gone the color of old concrete. Whatever Sutherland was saying in his ear, Dennis was shaking his head, once, very precisely. The judge called a recess. In the hallway, Sutherland requested a sidebar that lasted 19 minutes. I know because I timed it. 6 weeks later, the criminal referral produced a grand jury indictment. Leland took the stand and brought the shoebox. He answered every question evenly until the last one, when the prosecutor asked whether he had ever witnessed his parents actively searching for his sister in the years following her disappearance. Leland was quiet for a moment. Then he said, "No. They talked about her to other people, but at home she was just gone. They moved on." He looked up. I thought that was what grief looked like. It took me a long time to understand it wasn't grief at all. Dennis was convicted on 2 counts of fraudulent misrepresentation and 1 count of perjury. He was sentenced to 4.5 years. The sentencing judge noted for the record that the casino receipts dated to the week of a 6-year-old child's abandonment were among the most troubling documents she had encountered in her time on that bench. Glenda took a plea. She cooperated fully and received an 18-month suspended sentence, 5 years probation. She was required to issue a formal statement of acknowledgement to the court. It was 2 paragraphs. She didn't look at me when it was read into the record. I didn't need her to. The probate challenge was dismissed with prejudice. The estate of Miriam Holt passed to me as Miriam had intended, as she had spent 17 years quietly building toward. I kept what I needed, enough to pay off the house I'd bought at 29, in a neighborhood 2 miles from where Miriam's diner used to stand. The rest, $2.2 million, went into the Wren House Foundation, which Leland and I incorporated together in January. We provide transitional housing and legal advocacy for foster youth aging out of the system in Ohio. Kids who turn 18 and find that the state has stopped caring, and no one told them a safety net was supposed to exist. We make sure that when the system runs out, someone doesn't. We make sure that no child has to learn, alone in a loud public place, that they were always going to be left to figure it out by themselves. We named it for the pin. Miriam would have found that sentimental. She would have said so, flat out, and then been quietly pleased. Last spring, Leland drove down for a weekend, and we went to a diner near the river. Not Miriam's, which had closed after she sold the building in 2015, but the same kind of place, with laminated menus and coffee that's reliable if not remarkable. We sat in a booth by the window for 4 hours. He told me about a student he was worried about. I told him about a new housing partner we'd brought on. At some point, he asked if I ever thought about what would have happened if Miriam hadn't been at the terminal that day. And I said honestly, not much anymore. I looked at the Wren on my lapel. I wear it every day now, not as armor, not as a reminder, just because I like it. Because it was hers and now it's mine, and that's the whole story. The diner was warm and full of other people's noise. But underneath all of it, if you knew how to listen, and I do, I have been learning since I was 6 years old how to hear the thing underneath the thing. There was the quiet of a case that is fully closed. The silence of a debt that has been paid, cleanly, in the correct currency. I had spent 26 years counting, red suitcases, evidence files, statute of limitations windows, days since a bench in Columbus. I had counted my way out, and I had counted my way back to the place where the counting started. And I had stood there in a Hamilton County courtroom, and made it mean something other than what it was supposed to mean. Outside the diner window, the afternoon light was doing what it does in Ohio in May, turning everything a color that doesn't have a name, but that means you made it through. You counted all the way to the end, and look where the end put you. I ordered more coffee. Leland stole one of my fries. I let him.